When we tie everything from 1865 all the way to 2026, we see that we are still living directly inside the unfinished work of Reconstruction. The battle lines drawn right after the Civil War over who gets to be a citizen, how much power state governments have, and whether the federal government can protect equal rights never vanished. They just evolved. Here is how those 1865 post-war conflicts directly shaped the legal, political, and daily realities of 2026. 1. The fight over citizenship. Trump versus Barber, June 2026. In 1865, Southern states tried to limit freedmen from having basic rights. To put an end to that, the 14th Amendment was ratified in 1868 with the Citizenship Clause. If you are born on U.S. soil, you are an American citizen, period. In 2026, that exact Civil War era promise was brought before the Supreme Court. The court struck down Executive Order 14,160, which attempted to end birthright citizenship for children of undocumented immigrants in Trump versus Barber. The connection. The majority specifically pointed back to the 14th Amendment's original purpose, to overrule the idea of a second-class, non-citizen caste created during and immediately after the 1865 era. 2. The limits of voting rights, Louisiana versus Calais, April 2026. After 1865, states used black codes to bar black men from voting, leading Congress to pass the 15th Amendment, 1870, and eventually the Voting Rights Act of 1965. In 2026, the Supreme Court severely limited Section 2 of the Voting Rights Act in Louisiana versus Calais, ruling that plaintiffs must prove intentional racial discrimination rather than just showing that a redistricted map leaves minority voters with less opportunity. The connection. Just like the 1870s Supreme Court, today's court continues to push voting regulations and districting decisions back to state legislatures, shrinking the federal oversight created during Reconstruction. 3. The state action barrier. When the Supreme Court struck down the Civil Rights Act in 1883, it created the state action doctrine. The idea that the 14th Amendment only stopped government discrimination, not private discrimination. In 2026, that 1883 doctrine remains the foundation of modern civil rights law. It is why private business, digital platform, and private employers are treated completely differently under the law than government agencies. Summary, the big takeaway. Era, the core question, the result. 1865. Who gets to define freedom and citizenship, the federal government or individual states? States passed black codes, forcing Congress to step in. 1870s to 1880s. Will the Supreme Court enforce federal protections? The court repeatedly gutted federal oversight, giving power back to the states. 2026. How far do Reconstruction era protections actually go today? We are actively debating the exact same clauses, birthright, citizenship, voting rights, equal protection, in real time. The bottom line, the 1865 Constitution was the first attempt at a post-slavery America, but it was designed to give power back to state elites. Every constitutional debate today, from voting maps and immigration to state versus federal authority, is a direct continuation of that same argument. How equal are we, and who has the power to enforce it?